Hello and welcome to His72B Sq23 2023. I admit that the title of this package is intended to reinforce some themes I've been on about for the entire quarter. First, everyone, not just men, has work. There is not a time covered by this course in which the majority of women stayed home and acted delicate. Second, all oppressions are intertwined, which means that all rights movements must be intertwined to have hope of real success. We left birth control in the 1930s, so we are going to do a review taking us up to the 1970s and the development of the original hormonal birth control pill. We will look more at the pill in this as use became widespread and the part played by pharmaceutical companies with birth control in the 1960s and 70s, as well as the expansion of sterilization programs in the United States targeting marginalized communities. The Roe v. Wade decision was handed down in 1973. So I will cover the case and the use of the 14th Amendment in that decision. I don't usually build a coda in the outline, but this time it is the list of cases decided by the same interpretation of the 14th Amendment that are jeopardized now that Roe has been overturned. During the Great Depression of the 1930s, companies were eager to sell women contraceptives, but not permitted to by law. Women, who were barely keeping their already extant family members alive, were equally eager to purchase contraceptives. Companies used the term feminine hygiene to market a wide array of over-the-counter products that they believed to have a contraceptive effect. One of the most popular products was the simple and cheap Lysol douche, and yes, Lysol the cleaning agent. Scores of women relied solely on this ineffective and dangerous method to prevent pregnancy. On a more positive note, in the 1930s, rubber was replaced by latex and many barrier method forms of contraception. Single-use latex condoms were thinner, stronger, and seamless, a greatly improved product. This is a company testing condoms in 1935. In 1936, the U.S. Court of Appeals for the Second Circuit finally accepted a challenge to the Comstock Act. The full name of the case was United States versus One Package of Japanese Pessaries. Dr. Hannah Stone received a pessary specifically designed to prevent contraception through the mail. This was a new type of diaphragm from Japan, and it was seized under the Comstock Law. The court ruled that contraceptives were not banned if imported by a doctor. In his concurring opinion, Judge Learned Hand, and yes, that was his name, acknowledged that, quote, many people have changed their minds about such matters as contraception in 60 years, but the act forbids the same conduct now as then. A statute stands until public feeling gets momentum enough to change it. By the end of the 1930s, diaphragms, also known as womb veils, became one of the most popular methods of birth control. By 1939, nearly 400 community-based and state-sponsored birth control clinics existed throughout the United States. Going into the end of the 1930s, several national groups advocating for birth control had joined together. In 1939, they named themselves the Birth Control Federation of America. In 1942, the organization changed its name to Planned Parenthood Federation of America. In the 1940s, the diaphragm was the most effective form of birth control available in America, but also the least popular. Diaphragms required fitting by a physician and were extremely expensive. Doctors would only fit diaphragms for married women and only with the husband's permission. Even if a woman found a doctor willing to fit a diaphragm, women were paid considerably less than men. And if married, only the husband had access to the bank account. Effectively, nearly all women had to disclose and get permission for birth control from the sperm producer. The majority of women relied on inexpensive but significantly less reliable commercial douches for contraception. Lysol and Listerine, brand names that are still around, advertised heavily and made lots of money. In a step toward hormonal birth control, the 1940s also saw substantial progress toward the production of synthetic progesterone. While women on the home front in World War II douched to try to stave off pregnancy, the military panicked over the threat of venereal disease, or VD, meaning sexually transmitted diseases. The American military highlighted condoms on its approved list of prophylactics. Troops could purchase sets of 3 condoms for 10 cents at so-called pro stations, placed for easy access day or night. The military also created an aggressive advertising campaign promoting safe sex through prevention, combining images of sexy women with the not-so-sexy effects of VD. When you look at these images on the screen and others like them, notice women were presented as the vectors of disease, although in reality it was the soldiers that spread disease as they moved around. The suggestive double entendres, guns going off, the play on booby and unloaded, were all intentional. Weapons were heroic when they symbolized men, dangerous and scary when they symbolized women. The layers of gendered symbolism used in these propaganda posters goes on. You can have fun picking out more examples. The United States invested heavily in research of many kinds during World War II. The most horrifying result was, of course, the nuclear bomb. The most famous, perhaps, is nylon fabric, used for parachutes during the war and clothing after. But research also came up with new materials that would work well to make condoms. More efficient condoms meant fewer soldiers taken off the field by VD during the war. In the 1950s, Americans spent an estimated $200 million a year on contraceptives. Due to improvements over the past decade in condom quality and a growing awareness of the inadequacies of douches, rubbers, as they were dubbed in the US, became the most popular form of birth control on the market. Although the vast majority of doctors approved of birth control for the good of families, anti-birth control laws on the books in 30 states still restricted or completely prohibited the sale and advertisement of contraceptive devices. It was a felony in Massachusetts to, quote, exhibit, sell, prescribe, provide, or give out information about birth control methods. In Connecticut, it was a crime for a couple to use contraception. In 1953 and 1954, a team of biologists developed a prototype of the birth control pill. State laws prohibiting contraceptive research made it extremely difficult to set up trials in Massachusetts. But in order to get FDA approval, scientists needed to test the drug on humans. Scientists ran the first drug trials on 50 chronic psychotic female patients at the Worcester State Psychiatric Hospital in Massachusetts under the guise of a fertility study. Doctors inspected the women's uteri to see if the pill was working through surgery. By 1955, the results from those first human trials were fairly conclusive. None of the 50 women in the experiment ovulated while on the drug. Researchers were confident that they had found the perfect oral birth control pill, but the FDA required more extensive studies for approval to make and market Enovid, the first product name for hormonal contraception. The Worcester Lunatic Asylum, you're looking at it here, opened in 1833. For reasons that I do not quite understand, the insane asylum was a popular subject for postcards in the early 20th century. For reasons that I do understand, once the asylum was emptied of patients in 1991, until it was replaced in 2012, the old buildings were popular with the abandoned building set. The clock tower section has been preserved and moved, but the rest of the asylum is completely gone. The images of the patients shown here were taken in 1949, only 4 years before the beginning of the Enovid trials. The first large-scale clinical trials for the pill were conducted on poor women in San Juan, Puerto Rico. For researchers testing the pill, and having greater ambition than ethical scruples, Puerto Rico provided an ideal place for continued trials. After years of sterilization campaigning, widespread acceptance of family planning methods was solidified on the island, unlike in the mainland U.S., where cultural, religious, and legal hurdles were widespread. In 1937, Puerto Rico had passed Law 116, which made sterilization legal and free for Puerto Rican women. Family planning clinics offering free sterilization were installed in the new factories of the 1930s industrial wave on the island. Poor women in Puerto Rico were pressed to work in the needlework and textile industries. Employees received preferential treatment and payment with sterilization compliance, usually in the form of tugel ligation. For women in dire economic situations, the sterilization operation became commonplace. Concerted campaigns against coerced sterilization emerged in the latter third of the 20th century, but by the 1960s, about 1/3 of the female population had been sterilized. They usually had not been told that tubal ligation was permanent. Full trials on Enovid in Puerto Rico began in 1956. Participants received extremely high doses of the pill and were not informed that they were being given a prototype drug. Women reported nausea, dizziness, headaches, stomach pain, vomiting, and depression. Researchers labeled these symptoms psychosomatic. In other words, the physical symptoms were supposedly the result of mental factors in the women and not caused by Enovid. Scientists did the same thing when women reported bleeding and blood clotting. 3 women died during the trials, but no autopsies were conducted. Finally, the medical director in charge of the Puerto Rico trials reported to lead researchers that, quote, Enovid gives 100% protection against pregnancy, but the pill causes too many side effects to be accepted generally. Researchers had selected a high dosage of the pill in order to be absolutely certain that Enovid would prevent pregnancy without fail. In the spring of 1957, in addition to the Puerto Rico trials, head researchers also set up full-scale trials in Haiti and Mexico City. In the summer of 1957, the FDA approved the use of Enovid for the treatment of severe menstrual disorders and required the drug label to carry the warning that Enovid would prevent ovulation. By 1959, less than 2 years after FDA approval of Enovid for therapeutic purposes, an unprecedented number of American women mysteriously developed severe menstrual disorders and received prescriptions from their doctors for the drug. By late 1959, over 500,000 American women were taking Enovid, presumably for its off-label contraceptive purposes. In October of 1959, excited by the vast potential market for the pill, the manufacturer, Searle, filed an application with the FDA to license the 10 milligram Enovid, the same pill approved for menstrual disorders, for use as a contraceptive. The application was based on field trials with 897 women, making Enovid one of the most extensively tested drugs ever to come before the FDA for approval. In 1960, the U.S. Food and Drug Administration, or FDA, approved the first oral contraceptive, Enovid, a mix of the hormones progesterone and estrogen, to be used for no more than 2 years at a time. Enovid quickly became known simply as the pill. The 1960s saw the elevation of birth control to a national concern, in politics and rights movements certainly, but also in industry and the economy. As soon as Searle completed the requisite field tests demonstrating the effectiveness of the pill at lower doses, the FDA approved the drug for contraceptive use at 2.5 and 5 milligrams. The first company to make and market the pill was Searle Pharmaceutical Company. You are looking at Mr. G.D. Searle, looking suitably 1950s scientist here. The Searle Company has since been swallowed by Pfizer. Before that, however, the Searle Company gave the world Metamucil, Dramamine, and the artificial sweetener aspartame, first marketed as NutraSweet, in addition to the pill. As the pharmaceutical industry beyond Searle started to really assess the huge market for effective contraception, 13 major drug companies, 9 of them American, started research and testing to develop new birth control methods and their own versions of the pill. The pie chart here is for 2021. Birth control is still big industry now. By 1962, 1.2 million American women were on the pill. That year, Searle's corner on the pill market ended. Syntex received FDA approval to start selling their version of hormonal birth control under the name Orthonovum. Syntex started research about the same time as Searle, but Searle beat them to the market. As use of the pill climbed, so did word of serious side effects, including blood clots and heart attacks. Searle received reports of 132 blood clots, including 11 deaths. But as with the side effects noted in the human trials in Puerto Rico, the company brushed the new reports off. Searle declared that there was no conclusive evidence demonstrating that the blood clots were a direct result of the pill. By 1963, 2.3 million American women were using the pill, and by 1964, it was estimated that a quarter of all couples in America using birth control chose the pill. Searle earned $24 million in net profits, despite not having a monopoly on the market, from pill sales in 1964. Even as more companies joined the market with their own versions. The pill had become the most popular form of non-permanent birth control in America. In polls, a majority of the general public approved of birth control, although legal systems took longer to change. In 1964, 8 states still prohibited the sale of contraceptives, and laws in Massachusetts and Connecticut still prevented the dissemination of information about birth control. You can also see from the advertising here that although it was clearly women who took the pill, they needed sperm donor permission. So a fair amount of the marketing was actually aimed at men. In 1963, 2.3 million American women had been using the pill. By 1965, that number had risen to 6.5 million. Searle alone made $89 million in sales of Enovid in that year, in 1965. Also in 1965, the U.S. Agency for International Development began a population and reproductive health program with the goal of reducing birth rates in so-called developing countries. Somehow that just rolls off the tongue, right? While limiting the birth control available to middle-class white women in the U.S., the American government was already planning how to force it on women in those other nations. U.S. aid served and continues to serve purposes other than population control, and the U.S. government still contradicts itself on birth control policies both within and without the U.S. If I sound cynical on this, it has nothing to do with the pros and cons of birth control, but it has everything to do with who is making the decisions for whom and why. To return to middle-class white Americans who actually wanted access to birth control but could not get it legally, and the year 1965, we actually start with P.T. Barnum, famed for his circuses, who was a Connecticut state senator in 1879 and totally enamored with Comstock and his law. Under the Barnum Act, one of the most restrictive Comstock-inspired laws in the U.S., married couples faced arrest and imprisonment for using birth control. Now, you might ask yourself how anyone knew they were using birth control. The Barnum Act was still on the books in the mid-20th century, although most doctors ignored it for middle-class white married couples if there were health risks to the mother, which wasn't much help to anyone else. In the 1920s, Planned Parenthood had started building offices in Connecticut, not clinics because they couldn't offer birth control, but offices. Connecticut Planned Parenthood employees drove women over state lines to obtain birth control information in New York and Rhode Island. Estelle Griswold, one of these employees, became the executive director of the Planned Parenthood League of Connecticut, or PPLC. In 1961, in an act of civil disobedience, Griswold, with partners, opened a clinic in Connecticut where women could get birth control information. A few days after the clinic opened, authorities shut it, arresting Griswold and her partners. Just a reminder that we are in the 1960s already here. Griswold and her partners had enough influence and backing that they appealed their case all the way to the U.S. Supreme Court. In 1965, the Supreme Court finally ruled in Griswold versus Connecticut that married couples had a constitutional right to privacy that included the right to use birth control. In the 7-2 decision, the court struck down the Connecticut law prohibiting the use of birth control. However, the decision only applied to married couples. Millions of unmarried people still could not access birth control legally or easily. Writing for the majority, Justice William O. Douglas wrote, "Would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of use of contraceptives? The very idea is repulsive to the notions of privacy surrounding the marriage relationship." I notice that invading anyone's space if they are not in a heterosexual marriage is just fine. One of the concurring opinions rested on the 9th Amendment to make the same point. Two of the concurring opinions argued that privacy was protected by the Due Process Clause of the 14th Amendment. File that away in the back of your mind. Due Process Clause, 14th Amendment, privacy, as we return to the pill and the side effects of the pill. In 1966, the FDA organized a task force to look into side effects of the pill, especially the danger of blood clots, cancer, and diabetes. The task force failed to find a smoking gun, but it did allow the drug companies to bring lower doses of the pill to market with even less red tape. By 1967, over 12.5 million women worldwide were taking the pill. Meanwhile, the Pittsburgh branch of the NAACP charged that Planned Parenthood clinics, which provided the pill and other forms of birth control in low-income and minority neighborhoods, were devoted to keeping Black birth rates as low as possible. In a public statement, the organization, that's the NAACP, declared that birth control was being used as an instrument of racial genocide. By 1968, there were 7 different brands of the pill available in the U.S., and sales had hit the $150 million mark. David Niven and Deborah Kerr, who were stars at the time, starred in the Hollywood film Prudence and the Pill, and Comstock rolled over in his grave. At least we hope he did. Information that he had prevented moving through the post was now the topic of a major motion picture. The pill did not replace all birth control, however, and in 1968, the FDA approved intrauterine devices, or IUDs. Versions with names like Lips Loop and Copper 7 appeared, and within a few years, more than 10% of women using contraception had IUDs. You might remember or know that IUDs had to be inserted into the uterus by a doctor, which means that you had to get a doctor to help you. The side effects of the pill did not disappear just because the FDA and pharmaceutical companies pretended that they didn't exist. In 1969, medical journalist Barbara Seaman published The Doctor's Case Against the Pill, which laid out testimony and research showing that the high doses of estrogen in the early pill put women at risk of blood clots, heart attacks, strokes, and cancer. Influenced by Seaman's book, U.S. Senator Gaylord Nelson convened Senate hearings on the safety of the pill. Now, if it did occur to Congress to include women, they quickly stifled the very thought of such a thing, so groups of feminists disrupted the male-dominated hearings, making the radical demand that women taking the pill be informed of all the potential dangers and side effects. In 1970, the FDA ordered that all oral contraceptive packages must contain a patient information insert detailing possible side effects from the pill. While for middle-class white women, birth control meant getting access to contraceptives, for pretty much all other women, the issue of family planning was far more complicated. All groups of women shared the reality that men were the ones making decisions for their lives, families, and bodies, but women of color and poor white women faced forced permanent sterilization as part of that control. The data on the slide is from North Carolina. Note that sterilizations most certainly did not slow down after World War II, but that through the 1950s, the rate of sterilization of Black women began to outpace that of white women. This is North Carolina as well. A few points on these charts. In the top chart, note that the cumulative number of sterilizations did not level out until 1963. On the lower left, note that men were subject to forcible sterilizations as well, although they were greatly outnumbered by women. And on the lower right, the age of individuals subjected to forcible sterilization went as slow as 10 years old. North Carolina was not alone in forced sterilizations. Note that 3 of these charts go through 1983, and that the numbers of sterilizations from 1960 to 1983 are high. These charts are all from states in the South, but the South was not the only region practicing forced sterilization. Not all states practiced forcible sterilization, but all regions of the country did. These charts are from New England. The charts that I've been showing you in the last few slides come from the website that's listed on the slide. It has not been updated in quite a while, but it is a good place to look for information if this is a topic that you want to pursue. Over the course of the 1970s, the Indian Health Services, part of the U.S. federal government, sterilized thousands of Native American women. The average birth rate among Native Americans dropped from 3.7 children in 1970 to 1.8 by 1980. By comparison, white women's average birth rate was 2.42 in 1970 and 2.14 in 1980. California targeted Latinas with non-consensual sterilization campaigns. I strongly recommend this documentary, No Mas Bebes. It details one of the fairly recent episodes in California history and the women who pushed to hold those responsible to account. So this was forced sterilizations in Los Angeles in the 1960s and 70s, possibly up into the 80s. Forced sterilization was one issue, but so was coercive prescription of hormonal birth control. In 1970, Congress passed Title X of the Public Health Service Act, which created a federal grant program dedicated solely to providing low-income individuals with comprehensive family planning services, including contraceptives. Some people involved in this meant well, and some did not. But in every case, as with Native American women and Latinas, all women outside of white, middle to upper class were treated as interchangeable, all with the same issues, needs, and desires, if the desires were considered at all. In 1970, professor and activist Toni Cade Bambara's essay, The Pill, Genocide or Liberation, addressed the issues surrounding the use or non-use of contraceptives from the perspective of Black women at the time. The 14th Amendment was the middle of what are often called the Reconstruction Amendments. These were passed successively after the U.S. Civil War in an effort to combat white Southern attempts to return Black people to enslavement in everything but name. In this context, the 13th Amendment officially ended slavery. The 14th tried to clarify that, yes, freed people were American citizens and were entitled to the rights of American citizens. The 15th tried to solidify the vote as one of those rights for Black men. The 13th and 15th Amendments are fairly straightforward. This is the 13th Amendment. Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction, and Congress shall have the power to enforce this article by appropriate legislation. And that's it. This is the 15th Amendment. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude, and the Congress shall have the power to enforce this article by appropriate legislation. So those are both pretty short. This is the 14th Amendment. It is considerably longer and has far more opportunities to be interpreted and reinterpreted. This is the transcript of the 14th Amendment, and I will not read the entire thing for this one. You can always pause it or look it up. But I will read Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of the law, nor deny to any person within its jurisdiction the equal protection of the laws. This section defined citizenship at a federal level, and we've talked about that. Anyone born in any state of the Union was a citizen, and individual states were not supposed to be able to deny them rights, like trial by jury. As we know, this did not stop states from imposing Black codes and Jim Crow laws to deprive people of their rights based on the American construction of race. Arguably, the laws that led to inequitable incarceration now are the heirs of Jim Crow. It is also this section of the 14th that is at the heart of 20th and 21st century Supreme Court case decisions invoking privacy, like Griswold and Roe. We are particularly interested in what is called, for rather obvious reasons, the Due Process Clause. Nor shall any state deprive any person of life, liberty, or property without due process of law. This was the critical clause in Griswold v. Connecticut, allowing married couples to legally obtain birth control. Jane Roe was a pseudonym for Norma McCorvey. In 1970, she was a 22-year-old unmarried woman in Dallas, Texas. McCorvey had a 9th grade education, and she had already given up one baby born out of wedlock for adoption. She had no money, no support, and felt desperate. In her words, "I was a woman alone with no place to go and no job. No one wanted to hire a pregnant woman. I felt there was no one in the world who could help me." She wanted to terminate her pregnancy. McCorvey went to Linda Coffey and Sarah Weddington. Coffey and Weddington were practicing attorneys in Dallas. They were both recent graduates of the University of Texas Law School, and they were looking for a case to challenge Texas abortion law. Coffey and Weddington filed a suit in the U.S. District Court for the Northern District of Texas on behalf of Jane Roe. They argued that the Texas law was cruel and inadequate, especially for poor women who couldn't afford to travel to other states to get legal abortions. The Wade in Roe v. Wade was Henry Wade. He was the Dallas County District Attorney, and he enforced the Texas abortion law. In 1970, Wade was already a big name. He got national attention in 1963 when he was scheduled to prosecute Lee Harvey Oswald for assassinating President John F. Kennedy in Dallas. Instead, Wade ended up overseeing the conviction of Dallas nightclub owner Jack Ruby for fatally shooting Oswald at Dallas Police Headquarters. In June of 1970, a 3-judge federal panel struck down the restrictive Texas abortion law. The judges found the statute was too vaguely worded and violated the right to privacy in the 9th Amendment to the U.S. Constitution. You may remember that one of the judges in Griswold also relied on the 9th, while 2 others used the 14th. Wade appealed the decision to the U.S. Supreme Court, as did Jane Roe's lawyers, because the court dismissed their request for injunctions against enforcement of the Texas law. Jane Roe's case became national news. The Supreme Court decided to take Roe v. Wade in early 1971. Arguments in Roe v. Wade began in late 1971. At the same time, abortion was illegal in 29 states. The court held a second round of arguments in 1972 and issued their ruling in 1973. The court ruled, quote, that a woman has an absolute right during the first 3 months of pregnancy to decide whether to bear her child. Justice Harry Blackmun, in the majority opinion, wrote, "This right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty and restrictions upon state action, as we feel it is," by we he means himself, or in the 9th Amendment's reservation of rights to the people, is broad enough to encompass a woman's decision whether to terminate her pregnancy. Key points for Lecture 23 in Package H. In 1936, the U.S. Court of Appeals ruled that the Comstock Law did not apply to doctors who could receive birth control through the mail for distribution. The judge writing for the majority suggested that it was time to change the law. Companies started testing birth control using synthetic hormones in 1953 and 54, using women confined to an insane asylum in Massachusetts. Doctors used surgery to determine if the women ovulated. They did not while being given the test drug Enovid. In 1956, companies began testing Enovid in Puerto Rico. Corporations employing women were coercing their employees to be permanently sterilized to increase productivity by negating the possibility of becoming pregnant. Enovid seemed a welcome alternative, although test subjects were not told that they were being given a drug with unknown side effects. High doses of Enovid did cause side effects like blood clots, but these were downplayed, and Enovid was approved by the FDA for use in menstrual disorders in 1960. The U.S. limited birth control access for middle-class American white women while encouraging birth control use among women in the global South. By 1970, the pill came in a lower, safer dose, and by law included a package insert listing potential side effects. Availability of the birth control pill radically changed American culture, giving some women more direct control over their bodies. The practice of government forced sterilization continued through the 1980s in all regions of the U.S. Poor women, Native American women, Black women, and Mexican American women were all targets. The 1965 U.S. Supreme Court decision in Griswold v. Connecticut made birth control legal for married couples at the national level, based on a right to privacy reading of the 9th and the 14th Amendments. In 1973, the Supreme Court ruled that the right to privacy included a woman's right to a first trimester abortion in the Roe v. Wade ruling. This is one of the few codas that I really encourage people to watch, especially if you are concerned by recent U.S. Supreme Court rulings, and you should be. Abortion was not the only decision that rested on the right to privacy interpretation of the 14th Amendment. Rights past courts have considered protected under the 14th Amendment and endangered by the majority ruling in Dobbs v. Jackson Women's Health Organization, that's what overturned Roe, are the right to marry, the right to have children and raise them, the right to purchase and use contraceptives, the right of consenting adults to engage in same-sex sexual activity. And I will say also that sodomy laws in many places used to include any form of sex but penis and vagina for heterosexual couples as well. Technically, this first case is not a right to privacy decision, but since we already see pushback against birthright citizenship from certain sectors, I am including it. In 1898, the Supreme Court affirmed the principle that children born on American soil are U.S. citizens, regardless of their parents' status. Wong Kim Ark was born in San Francisco to Chinese parents. Anyone from China was prohibited by law from becoming a U.S. citizen, so Wong Kim Ark's parents were permanent non-citizens. The court ruled that birth in the U.S. outweighed other factors and conferred citizenship. 1954, Brown versus the Board of Education ruled that separate educational facilities are inherently unequal. In 1954, the Supreme Court ruled that the 14th Amendment protects public school students from state-sanctioned segregation. 1963, Gideon v. Wainwright was related to legal counsel for indigent defendants. The Sixth Amendment guarantees defendants facing imprisonment the right to an attorney. In Gideon v. Wainwright, the Supreme Court held that this rule applies to the individual states through the Due Process Clause of the 14th Amendment. Mildred Jeter, who was Black, and Richard Loving, who was white, were childhood sweethearts who wanted to get married. Virginia had so-called anti-miscegenation laws on the books, banning marriage between a Black person and a white person. Virginia enforced its anti-miscegenation laws. The Supreme Court ruled unanimously in the aptly named Loving versus Virginia that state bans on interracial marriage violated the 14th Amendment. In 1971, Idaho legally required that in any challenges over a state and children, a man be selected over a woman, meaning that custody of children would automatically go to the father. The Supreme Court ruled that laws based on gender discrimination went against the Equal Rights Protection Clause of the 14th Amendment. Reed was, in fact, the first time that the Equal Rights Clause of the 14th Amendment was used to decide issues of sex discrimination. A law professor from the Rutgers University School of Law in Newark wrote the brief submitted to the Supreme Court on behalf of Sally Reed. And if you were listening but not watching, the professor who wrote the brief was a very young Ruth Bader Ginsburg. The Supreme Court decision in favor of Sally Reed and of Ruth Bader Ginsburg's brief was unanimous. I've already covered Roe earlier in the lecture, so I will just add a bit here. The Supreme Court ruled that the 14th Amendment and right to privacy protect a woman's right to terminate a pregnancy without excessive government restriction. The 1973 decision includes the phrase, "This right is not absolute." Effectively, abortion was already illegal in most of the U.S. before Dobbs, the decision that overturned Roe. The Supreme Court decision in Dobbs is not actually or only about abortion. It is about the 14th Amendment, specifically readings of the 14th Amendment that underpin rights we know are threatened, as well as ones we take for granted. I've given you some biggest hits cases here, and I will give you one more in the next slide. But I encourage you to learn as much as you can about the 14th Amendment as soon as you can. In Obergefell, the U.S. Supreme Court ruled that the 14th Amendment protects the right of same-sex couples to marry. I've put a photo of the Supreme Court in 2015 on the slide. The Obergefell decision was 5-4 then, and that is not the Supreme Court that we have now.